already account
Yeah,
to.
let's do this. She's in our custody. All right. Let me pass it. Get the sheets to me so that I'm real clear as to what exactly we're. And we're going to check and see if they're somewhere buried in the files before you
Your
start.
Honor.
I'm going to pass. Yes, ma'am.
Thank you.
I'm going to pass your matter, but we're going to get you called up and hopefully get your case resolved today. Okay.
Yes, sir. And then I'll be able to go home.
I don't know that.
Come on, you know that.
What?
You, if anyone, if no one else knows, you know. Come on, Your Honor. I've been here almost a year.
Over by a vehicle. That incident was a wake-up call for me. Since that moment, I've made a commitment to myself and my family to stay clean and change my life for the better. Judge, that's a significant change. Have you struggled with mental health issues in the past? Defendant, yes, I was diagnosed with bipolar disorder when my daughter was born. They prescribed me medication for it, but at the time, I chose not to take it because I didn't want to rely on medication while raising a young child. I've been living without treatment since then. Judge, so you've been living without medication? Defendant, yes, Your Honor.
You are absolutely right, and maybe I'm just not telling you.
Okay. So I'll wait on it.
Court does call the case People versus Jeremy Walter.
Ashley Lonnie for the people.
Hey, Judge. Portia Feaster, Assistant Public Defender, appearing on behalf of Mr. Walters. Mr. Walters, when you get here, please state your name.
Jeremy Walter.
All right.
Thank you, Judge. My understanding is this is a case that Mr. Walters had previously asked to adjourn to seek new counsel, to retain counsel. He has not been able to do that this time. I'd ask for its immediate adjournment so that he and I can sit down and talk, go over his case, and see about possible resolution, Your Honor.
Adjourn it, but what about his bond violation?
Yes, Judge. As it relates to his bond violation, I did speak to Mr. Walter about it in the hallway. Mr. Walter did say he was aware of the THC positive. He said he asked Community Corrections to send that off for further testing. He paid the $30 fee for that, as well as went to the therapeutic center that does his additional drug testing, and they did a second test.
When?
Within 24 hours of the positive test you received there, and he's expecting a result from them any day now. If the court wants to have those results in the near future, I'd ask the court to consider just adjourning it 1 week.
Well, I guess my question is he saying it shouldn't be in his system at all?
That's what he's saying, Your Honor.
Yeah, I did not knowingly ingest THC, but I do have a medical card. But
You have a medical marijuana card?
I do. It may need to be renewed, but I do have one. Oh,
This says you report not having one.
I think it's expired, Your Honor. I
What?
don't think it's valid. I think it is expired, I believe, Your Honor. So I don't think he has a valid card. He may have a physical card, but not a valid physical card, Your Honor. My understanding of talking to him, like I said, my first time talking to him, Your Honor, he says he did not use any THC, and that's why he paid for the additional testing, and that is why he went and got the second test within 24 hours. So he should have some verification.
So you were just somewhere and this THC snuck into your system?
I don't really know how to.
Really?
I would.
No, hold it. Are you? So Mr. Feaster will explain to you how I am.
I did
Yeah,
already.
So I just want to know, is that the story you're sticking to tell me?
Well, I
Oh, no,
understand.
What he's saying is, like we talked about in the hallway,
Mhm.
if you did accident or choose to use marijuana in violation of your bond, it is best to tell him the truth today
Right,
and not say you didn't do it if you did do it. If you didn't do it, then you can.
and I didn't do it.
Okay.
I'm
So
100%
if we
confident that.
if
But I don't
we
know.
tested you today, your levels would go down for winning that other test,
Yeah, or it'd be non-existent.
or non-existent.
Yeah,
Okay.
I'm happy to.
Oh yeah. Oh, you can be happy with that.
0111 162, State of Texas versus Nicole Nutter. Court proceedings begin. Judge. Now, regarding this incident, were you using methamphetamines at the time of your arrest? Defendant, Nicole Nutter, no, I wasn't using meth. And no, I wasn't on any medication like Depakote or anything similar. I wasn't taking anything at the time. What happened was I had a mental breakdown. There's really no other way to explain it. I wasn't under the influence of anything. Judge. All right, make sure to speak up so the court reporter can hear. Now,
You're gonna go over and get tested,
All right.
and we'll see what the results are. And then I'll make my decision as to what I'm gonna do with them.
Thank you, Judge. So you're going over the community questions right now, what Judge is telling you.
Yep.
I'm sorry. I noticed on the bond violation report that when the defendant went to do his initial intake, he said he didn't have money to test, which is why he wasn't tested that day. So we just confirmed that he does have money before he sent over there to prevent us having to come back and everything.
Do you have the funds to be able to test today?
I do.
He does, Judge.
Okay.
Thank you, Your Honor.
You're welcome.
Appreciate it.
All right.
Okay,
Okay.
he can head over and you'll let them know he's on his way? All right, go test. Thank you. You ready, Mr. Feaster?
As ready as I'm going to be, Judge.
Court does call the case, People versus Jeremy Walter.
Ashley Lonnie for the people.
Torshov Feaster, Assistant Public Defender. On behalf of Jeremy Walter, to the podium, please.
Jeremy Walter.
Thank you, Judge. I did, thank you for giving Walter the opportunity to go to community corrections and to have his, another sample given and tested. We did receive the results that sample was positive. I followed up and asked for the levels from the February 18th date to today, the 2/20 date, and those levels do appear to have gone up. So,
Oh, skyrocket would probably be a word.
well, yes, Judge, that will be accurate.
Okay.
My client, I spoke to him about the skin and asked him if there was anything he wanted to tell the court to clarify things. He's still adamant that he did not use any marijuana intentionally, and I informed him what was likely to happen, Your Honor.
May I respond?
You may.
Thank you. What's of particular concern to the people in this case is that really the 218 test, the test on Tuesday, is our first test.
Correct.
The defendant was placed on bond, I want to say the middle of January, but I'll have it pulled up here in just a moment. And at the time that he initially went on 117, he said he didn't have the money. 127 he missed, 24 he missed, 214 he refuses, 218 we finally get a test and it's positive, and today 220 the test is increasingly positive. The reason that I'm particularly concerned in this case is because there are underlying mental health issues at play. The people do believe that we're at least in part responsible for the things that led to the charges. In my professional experience, the combination of THC with mental health challenges can be really disruptive and can be difficult. I am very concerned about the defendant and his behavior while on bond, and I will leave any decision about the bond violation to the court's discretion.
Only thing I can say to his credit, Judge, that he did go test when we ordered him to. He come back. He did not flee, run. He's not sure how it's got in the system. He did have some housing insecurity. When he thought there might be some using at that location, he left that housing location to make sure he was not around any narcotics. He's not sure how this could have occurred, but he's obviously very apologetic that it's positive, and he understands the court's how the court treats these situations generally. I've made that very clear to him, but he says that he has not been using to his knowledge, Your Honor.
I'm not even sure what to say. I mean, as I'm looking at this, it's clear that first of all, we had a series where he's not testing. Then he's unable to test. Then he tests, it comes back positive. Then we're not necessarily dealing with it at that time. And then I get him here and he's got an opportunity to tell me something's going on. And he's telling me it's all he's not sure, or some mistake on his part. And then I get the levels and It's clear it's not a mistake.
Like I said, to Mr. Feaster here, that I was, because of my bond stipulations and the no contact order with my parents, which is where I was living before, I was living in a place that I realized was
That trailer park. Was that your friend's place you were staying at? Defendant. Yes, it was my friend's house where I was living. Judge. Were you allowed to be there when you went back? Defendant. I thought it was fine, but there had been some tension a few days before. I didn't think anything of it, but I had spent the night at another friend's place afterward. Judge. So, you weren't officially kicked out? Defendant. No, he gave me my clothes and said I should go stay somewhere else. We didn't talk much about it, but he had given me my things, and I left. Judge. Did you intend to burglarize the
not safe, and I about 36 hours ago moved out of there because I realized that people were using there, and so I moved. I put everything in my car, and I moved to my to a place where I can be safe and be private and not be around people using. So I made a significant effort to remove myself from a situation that I realized was dangerous. So I am making significant efforts. It was not easy to move, to put all my belongings in my car, and to have faith that it was going to work out for me to stay in an office of the nonprofit that I volunteer at. But I made that significant change in order to remove myself from a potentially hazardous situation. I'd just like to say that.
Only thing I'll add, Judge, is that my client was trying to retain counsel in this case. He's met with two different attorneys. I think he's planning to have one for his next court date. I'd ask the court for the soonest possible adjournment the court is able to give him so that he can hopefully see you again and have new counsel present for that next court date.
Probable cause conference will be adjourned to February 27th. I'll set it to next week, 2025, 9 a.m., or as his invite indicates. At this time, given the positive test, and I don't believe that the defendant is telling me the truth at all, that he's intentionally violating the conditions of his bond. So for those reasons, I'm going to revoke the defendant's bond. Defendant is remanded.
Thank you very much, Judge.
As to bond.
As to bond, I believe Mr. Ante Scott is being held right now on case 25FB1013. There is a 5,010% bond on that case. My understanding is that this court gave Mr. Ante Scott a personal recognizance bond, a $5,000 personal recognizance bond yesterday in case 2411706. I do believe that the reasons why a personal recognizance bond would have been justified then count for this case as well. Mr. Scott is not a flight risk. He lives in the community. He is willing to follow any kind of conditions the court sees appropriate in order to be released. He would just like to.
No, he's not.
He would just like to return.
He's going to give, I will say this. Don't look at me like that, Mr. Scott. We've been through this before. He's going to give his best effort. He really is. He's going to try his hardest, and then it just happens. Go ahead, counsel. I didn't mean to interrupt you, but I just had to, because I know Mr. Scott told you that.
Well, on Mr. Scott's behalf, it is just this one case that is holding him, and it does appear he has personal recognizance bonds in all other matters that he has. So I would ask, just because Mr. Scott would like to be able to kind of, family, attend to his health matters, and work out in the community while he is handling these cases. He would request, and I would request.
He got to go see now. Which family member?
My grandma, my granddad.
Okay,
and just my sister and stuff, the people that was helping me out in the past years. That my auntie. And I won't. I'm just gonna do the right thing. Just bear with me one time.
One time.
I mean,
How many times have you been here?
uh,
Can't even count that high, can we?
no sir.
No, we can't.
But I will do what you tell me to do. Just please.
Anything else, counsel?
I would just like to, reiterate that I understand that a matter was before this court yesterday, and it seems like a personal recognizance bond was appropriate at that time.
Only because I knew it was going to be held on this one. But go ahead.
Well, I'd ask the court to consider this bond motion in light of the argument presented.
Response from the people.
Your Honor, I leave it to the court's discretion.
Just tossed it right in my lap. Okay. What was your charge on the case you had before me yesterday?
Just a paraphernalia gave me personal personal bond, and you told me conditional yesterday, and I thought I was leaving yesterday, but that's
I know.
And Your Honor, I would add that Mr. Ante Scott is willing to go on tether in this court if that is.
We tried that too.
If
The only thing the tether did for us is we saw where you got in trouble. Sometimes I have no idea what I'm doing. I'm going to grant your motion for a bond reduction. I'm going to give you a PR. Barrage,
yes, sir.
understand something.
Yes, sir.
You still have the case before me.
Mhm.
Okay?
Yes, sir.
So if you mess up, you know what I'm going to do.
Yes, sir.
And then I don't want to hear any whining and pleading.
Yes, sir.
Here's the other thing I'm going to do. I'm going to call Judge Slay.
Okay.
And I'm going to let her know what I did.
Okay.
And if you mess up, you're going to have.
Defendant, no, not at all. I just wanted to talk to him about the cats I had let out of the cages and let him know what was going on. Judge. All right, so the judge will need to consider the likelihood of you successfully completing probation. You've had probation before, and it hasn't gone well, right? Defendant, yes, I've struggled with probation in the past, especially with my bipolar disorder. But I've been medicated now, and I feel much more stable. Judge, has your mental health always been a factor in these issues? Defendant, yes, it has. That's why I got myself medicated.
Both of us deal with.
Yes, sir.
And I don't think anybody wants to deal with that.
No, sir.
All right.
So can I ask one question?
Oh, boy.
Mr. Scott, I would advise you.
No, you can go ahead and ask a question.
No,
because I may change my mind. Go ahead. What's your question?
No,
bro?
I was just gonna ask you. I can't remember. It's okay.
You couldn't remember?
I can't remember.
It left you, didn't it?
Yeah.
Yeah, that's probably a good thing.
That's all I want to say.
That barrage, that's angels just stepping in and stopping you from doing something stupid. All right, thank you.
Thank you, Your Honor.
He'll be back in a week. What?
We all, we're
We're rooting? Oh, okay, we're rooting.
No, it's radio silence.
Yeah, no, everybody over there is not. Everybody from the prosecutor's office. We have faith, yeah. All right. Nothing from the defense side. All right.
Allison Miller, Assistant Public Defender, here on behalf of Brianna Kingsley. Brianna, can you state your name, please?
Good afternoon, Your Honor. I'm Brianna Kingsley.
Good afternoon. So you haven't submitted the mitigation.
No, Your Honor. No, I'm meeting with Brianna this week, and we will provide that to the prosecutor this week.
All right. Probable cause conference, March 13, 2025, 9 a.m. as your invite indicates. Bond will continue.
Thank you.
Your Honor.
Thank you. Where's your dog? Miss Kingsley? Where's your dog?
Well, the short version of that story is I came to court on an outstanding warrant out of IPSI 5 times, was turned away 5 times. And when I was at Meyer, my dogs were in my car safe and someone called 911 and they were taken to Washington Humane Society. And the circumstances of my homelessness, I wasn't able to retrieve them.
Oh, I'm sorry.
I am hopeful that they found a good home with kids.
Okay, I'm sorry. I didn't, it's just that you were always here and he was, the one was with you all of the time. I
It's
just,
been a journey, but I'm trudging.
yes.
Thank you.
All right, take care.
Court calls the cases of the People versus Forbes Dabney.
Morning, Your Honor, Randy Cook of the People.
Good morning, Your Honor. James Fifelsky appearing on behalf of Mr. Burmeister, who is approaching. Good morning, sir. Please state your name for the judge. Kyle Burmeister. Your Honor, this is our first PCC. I am asking for a 30-day adjournment. One of the things I need to gather are medical records that I think will be relevant to our defense or potential resolution, and those often take more than a couple of weeks.
Who's medical?
My clients. Got signed releases that are going out today.
On an unlawful driving away and I don't,
Well,
not understanding it.
I think they'll be very relevant to the RO charge and medical history that I think will be important to review with the prosecuting attorney.
Any response from the people?
Your Honor, just, please one moment.
Sure. Got all the time in the world.
Your Honor, may we briefly approach?
Didn't have that much time, but yeah, come on.
That I had was today. No, all I saw the paper was this.
Right, okay.
There was only one. It was today.
Your Honor, just to advise the